Good evening to everybody. I welcome all of you to the 11th webinar hosted by the Bar Association of Sri Lanka. Our topic for today's webinar is Connecting Through Digital Platforms, Data Protection and Cybersecurity. We have an eminent panel of experts as resource persons for today, and let me introduce them to you. Mr. Sunil Abhiratna, attorney at law, is a former secretary of the Bar Association of Sri Lanka. Mr. Abhiratna has held and is holding several distinguished posts, and may I mention a few. Co-chairman, Communication, Data Protection and Technology Law, Law Asia, Secretary, Employment Law Committee, Law Asia, former Vice President and EXCO member, Law Asia, Chairman, Institute of Legal and Management Studies of Sri Lanka, Chairman, ICT Lawyers Guild of Sri Lanka. He is a visiting lecturer and examiner of the Faculty of Law, University of Colombo, Faculty of Medicine, University of Colombo, as well as Law Department of University of Peradeniya. He is a lecturer at Sri Lanka Law College, Apit Law School, and NIBM. Mr. Jayantha Fernando, attorney at law, he is the chairman, Lanka Internet Registry, director, legal advisor, Information and Communication Technology Agency Sri Lanka, and chairman, Data Protection Bill Committee. Mr. Chanakya Jayadeva, who specializes as entertainment and media law attorney. Mr. Jayadeva is a regular speaker and resource person on World Intellectual Property Organization seminars held in Sri Lanka. He has authored the books Entertainment and Broadcasting Law for Sri Lanka and International Entertainment Law and New Media Law. He is also a television host for the National Television of Sri Lanka. Ms. Andanu Wickramasinghe, attorney at law, senior legal officer, Mobitel Private Limited, and member of Personal Data Protection Law Drafting Committee of the Ministry of Digital Infrastructure and Information Technology. Mr. Senra Bevardhana, attorney at law, who is the moderator for today's session. He is the Public Policy Manager, Facebook. Over to you, Mr. Bevardhana.
Thank you very much, Pasindu, for that kind introduction to me and the rest of the panel, who will be talking on the topic on connecting through digital platforms, cybersecurity, and data protection. As you all know, the internet has been a revelation which connects the whole world, and it has multiple uses. And as part of its use, there are many third-party platforms which may be intermediaries, or maybe even direct service delivery platforms, which helps people connect for different use cases. It can be for business purposes, for meetings like this. It can be for recreational purposes, educational, and even entertainment. Um, all these use cases have sprung up like many issues such as data protection, privacy, safety of the users, like cybersecurity, as well as how do you treat content which people post, share, stream using these intermediary platforms or direct service delivery platforms. To address these issues, I would like to call upon Mr. Sunil Abhiratna, who will just set out the format. Uh, each speaker will get about 12 minutes, 10 to 12 minutes, to just outline the key issues that they would address. And at the end of the presentations by the four speakers, there'll be a Q&A session. Um, I would like to invite Mr. Sunil Abhiratna to address the issues of what are the available laws in Sri Lanka to deal with the issues highlighted here. And he will also dig deep into his expertise and experience and share some interesting perspectives on that. Over to you, Mr. Abhiratna. So you're on mute.
Um,
No, sir. I think you're still on mute, sir. I think you're okay now.
Yeah. Can you hear me?
Yes, we can hear you, sir.
Right. So thank you very much, Sandra. Thank you very much, Pasindu, for kind introduction for me. Now, first of all, we must understand what is this that digital platform, and what is the application of ICT development to various professions, then business community, and the service sector, and other areas. Now, mainly the medium of communication and medium of transactions has been changed under the development of ICT industry. Earlier, we used the same transaction with paper-based medium. Now we are using electronic medium. So when you have these transactions over electronic medium, considering its nature and the behavior, that we must consider whether we can apply the same existing laws, regulations, policies to this electronic medium as well and as it is. This is the biggest challenge before us. Now, take example, what is the application of ICT development to that medical profession? Now, medical professionals, they are using various the machines. Say, take example, scan machines like that. What are these machines? Now, we have that key statute relevant to ICT. When you take interpretation for computer, all these machines are computers. Even engineers draw the high-rise buildings, bridges, everything using computers and network. Even accountants of the same. Now take business community. Most of the leading enterprises in the world, they use computers and network to carry out their business transactions. Even banking sector. Today, the bitcoins and cryptocurrency are the popular among the business community. Even the service sector. Take example, the country like Germany and France. They have computerized their transport system. So as a result, at the moment, as far as this development of ICT sector is concerned, all that human on the earth have been benefited over the ICT development. Now, anyway, when we use this technology, that we must understand there are some people who misuse this technology. And day by day, lots of disputes, lots of problems, issues are coming to the world. So as a result, there's a direct involvement of the development of ICT industry to the legal profession. Finally, when there's a dispute, when there's a difference, it will be ended up either before a tribunal or a court or before arbitration or whatever it is. So that is why, as the members of this profession, that we must know and we must understand the development of this industry and the behavior of electronic medium, new invention to this sector. And finally, that we must understand whether we have to, when we go to apply the same existing legal provisions or laws or rules, regulations and policies relevant to various areas as it is, so what are the practical problems we would face in future? Now take example, when you have the commercial transaction, when we use this electronic medium to carry out various business transactions, today we identify these commercial activities are electronic commerce. The main issue is whether we can apply laws and policies related to law of contracts as it is to electronic commerce. Or either we have to modify the existing legal provisions, or we have to replace some provisions to fit into that electronic commerce. That is one area. When you come to banking sector as a part of electronic transaction, whether we can apply same electronic fund transferring system and the laws and policies behind the fund transferring system for electronic fund transferring. The second area is when we have transactions, whether our transactions are secure. Prior to these electronic transactions, that the world had some traditional system, and we had some issues relevant to those transactions using paper-based medium. But when we convert that medium into electronic transactions, now the new issues and new challenges are before us. Now take example, whether our transactions are secured. Can we apply the same security methods we applied earlier for paper-based transactions? Or if we have to apply new security, what is the legal impact on this new legal security issues? So likewise, now when we have this transaction, there may be some people who misuse these transactions. And what is the criminal liability under criminal justice system against this wrongdoers? Now take example, we have the penal code, and number of the statutes comes under criminal justice system of the country. But after introducing this electronic medium to the system, now we can see that new offenses, the nature of offenses are becoming traditional into high-tech. Under these circumstances, can we apply the existing legal provisions under the penal code and some statutes as it is on the offenses based on computers and networks? Then again, there's a question arises whether we have to modify these existing legal provisions or we have to introduce new set of offenses to deal with these issues. Then the new methods we have to apply to collect evidence, to seize, analyze, preserve, and present before tribunals or court in legal proceedings. When we produce electronic evidence, considering its nature and the behavior, can we apply the existing legal provisions under law of evidence available in the country as it is on this electronic evidence, or whether we have to modify? Whether the question arises whether we can stick into the best evidence rules and rule against hearsay anymore when you are going to apply electronic evidence before court, or whether we have to deviate from our original concepts, or whether we have to modify the existing legal provisions within the framework of the law of evidence. When we are going to modify the existing framework, whether we are going to jeopardize the existing legal provisions. So these are the biggest challenge before us. Now, when we come to dispute resolution, what is the jurisdiction? What is the jurisdiction? How to decide the jurisdiction to go for litigation or arbitration or mediation or whatever it is. Then when you come to intellectual property rights under ICT, whether we need the new provisions to secure new intellectual property rights relating to the software industry or ICT industry. Now take example, prior to 2003 Act, there was no copyright given for computer software. But after introducing 2003 Act in Sri Lanka, following various treaties, international treaties, now our law recognized computer software and given copyright and that even patent rights and topography, like the various rights for computer programs. Then when it comes to investigation, finally, we will ended up before, as I explained you earlier, before a tribunal or court. What are the forensic issues involved in computer evidence? When we are going to apply, when we are going to introduce this evidence before court, can we invite the presiding judge to accept certain electronic evidence as genuine evidence? Now take example. Under Prevention of Fraud Ordinance, there are two requirements to accept a document as a valid agreement. It must be in writing or it must be authenticated. Now, as far as the provisions, section 3, 4, 5, and 6, up to 6, right? When these sections are concerned, under Electronic Transactions Act, the first requirement will be fulfilled. The legislature has tried to harmonize the situation and to bring the electronic document to the level of normal document. So therefore, the legislature has introduced this section. When it comes to authentication, after introducing amendment to Electronic Transactions Act 2006 by Act number 25 of 2017, following United Nations UN new convention on international electronic contracts, Sri Lanka is signatory. Legislature has brought the new section 7 to dealing with authentication. Now, when it comes to authentication, what are we going to authenticate? Authenticate with a document. We will authenticate the document. It can be electronic document, all right? It is a document. Now, under normal circumstances, we know we authenticate document means we give the guarantee, the authentication of the contents of the document. Now, can we apply the same theory here? When we authenticate an electronic document, can we trust the contents inside this document? Now, take example, metadata. Metadata means data within data. If we have electronic document, the metadata shows what is the date, the date of creation, and whether that after a question arises, after retrieving that document, opening that document, after amending, or if we even include some items to that document, and save the document again, can we get the same metadata for that document? Can we show the same date of creation of that document? So metadata is changing. Now, under normal circumstances, we don't have that problem. But when we come to electronic document, these are practical problems. From the beginning, at the time of signing electronic contract, we must expect dispute. Then, of course, we can preserve a document. But when we start with certain matters, we can't predict. We can't predict any issues. But when these issues arise only, that we will start to collect data and preserve data. So sometimes we can't give accurate details about the document. So there are some mechanisms have been applied in various countries. Take example, United Kingdom, even in Australia. As far as their criminal procedure rules and civil procedure rules, that we can see that how they maintain their procedure to fulfill this requirement, to overcome the situation. So these are some issues that we can see under the development of ICT industry. In Sri Lanka, starting from Evidence Special Provisions Act in 1995, then Electronic Transaction Act introduced in 2006, amended by Act number 25 of 2017, then Computer Crime Act in 2007, and we have ICT Act. Now we can see the draft law on data protection and cyber security. We have legal framework, but at the moment we don't have very strong regulation. We can't see to strengthen these laws. So at the moment we have legal framework, but what I feel is, in future, under the development of this ICT industry, now the time has come to modify our that available statute, because the statute starting from 1995, then 2006, 2007, 2017, and 2003, the Intellectual Property Act. Because every day this ICT industry is changing, modifying, and the platforms are also changing. Earlier, we didn't use this webinar with Zoom or that Microsoft Teams, this program, but now we are using that. Now, one more that after this COVID-19 issue, now people are used to carry on these meetings, lectures on online basis. Now people have started to use online banking.
So I have to...
Under these circumstances, that let's see that how we are going, how to change the laws and what are the areas that we have to rethink or to modify. With that, I will conclude this my presentation.
Yeah, thank you very much, Mr. Abhiratna, on the initial comments on how the application of the existing laws for issues that arise from the digital space, which affects and props up questions on jurisdiction, intellectual property, forensics, and how evidence can be led. And you took the example of authentication using metadata. Thank you very much for that. Now we would like to move on to Mr. Chanakya Jayadeva, who will take us through the issues of content, basically how about posting content, sharing content online, or streaming content, and what are the legal issues that arise from that. Over to you, Mr. Jayadeva.
Can you hear me, Senator? Senator, can you hear me?
We can hear you. We can hear
right.
you.
Okay. I thought I was after Jan, so that's why I was relaxing. Anyway, in a short span of time, I will try to explain as much as possible on the IP aspect and several aspects that are important to us when we are doing online streaming or any kind of online activity in the digital platforms. This is not something I can summarize in 12 minutes, but I'll try to do my best. Almost everything I'll be talking here will be regarding to y'all, the user-generated content, that is the people who are using digital platforms. It is largely not to the people who are ISP providers or the service providers or the platform providers or anybody like that. Because people who get into trouble most of the time is the people who are using it. So I'll touch upon the IP aspect issue first, which revolves around mostly because of the most of the questions revolves around that because of video and audio streaming which we do or uploads which we do, and litigation across the world has found issues on those areas as opposed to most the postings which we do in texting. Now, video recording or uploaded video or streaming, what are the things one need to be aware when it comes to IP rights or privacy rights, which are the two things that are hanging around any video posting or video streaming, is that where you shoot or what you shoot or where you are streaming that video from. The basic premise of copyright, as we know, is there for the person who does the video, shoot it or live stream it. The owner is the copyright holder is the person who does that. But that does not, as you know, most of you know, give you the right to violate that, the moral rights of the people whom you are shot in that, who's inside in that video. You have the right for the video or the photo, but not to violate the moral right of the people who are inside it. So when you are shooting something or if you are live streaming something, it's always, you have to, one of the things you have to understand that in most countries, including Sri Lanka, if you do it in public places, you're free to shoot in any public place in most of the states, and people who are behind you, around you, do not have a right of privacy for to a limited extent, have right of privacy over they are being shot on that. But it stops that right to do anything with that video stops if you are trying to zoom into private properties or make intrusive close-ups or things like the paparazzi used to do, or taking shots of people who are traveling. This is because of the law of privacy, which is recognized worldwide. Now, a lot of people question me as well that we don't have a law of privacy in Sri Lanka, which is wrong. We do have law of privacy recognized in Sri Lanka under the Roman Dutch law, because Roman Dutch law recognized the law of privacy concept, and we had lower court recognition of that, and our not the Right to Information Act also recognized statutorily the law of privacy, and I think the Computer Crimes Evidence Act also, Computer Crimes Act recognizes it in an indirect way. So we do have recognition of privacy. So you have to watch on the length of intrusion of your photography or videography, or when you're streaming of by your personal devices or using a camera, and especially when it is on a digital platform. It applies to other platforms as well. So, and the other thing is, even if you shoot in these places, these things in a format, in a way that it is in a public place, public places other than any private place, like I explained, you cannot use those images, people who are in that, for a commercial purpose. That is because of another right called the right to publicity. That is, if you shot something with some people who are in a video randomly in a public place, in a city or somewhere, anywhere in the world, you can use it, for example, in a TV commercial or music video or some kind of video which you post again online, because that will violate that person's right to publicity. Right to publicity, in short, is basically the fact that whether they want to be associated with you in that particular production, or whether they do not want to be in that video. So if you want to do that, you will have to get a clearance from people who are inside that. Now remember, these apply to other things you find in the videos as well, which you shoot, whether you live stream or record it. Now, I was talking all this about the people, but what about the trademarks, artwork, sculpture, or even architectural designs of big buildings? Now, those people also can oppose. If you are innocently recording that or streaming it live, it doesn't matter. But if you are using it for a commercial purpose, or a private video, or a film, or something like that, you cannot accidentally have a trademark in the behind of Coca-Cola or something like that, or an artwork of somebody, or even a big architectural building. Sometimes even the public buildings are protected, ancient buildings, especially those people who own that. Sometimes it can be the state, sometimes it can be private people, can object to that being featured in a production, because they would not, again, like the people, as we want to be associated with that. That is because all such products are protected by IP laws. The creator has the placing right wherever he want to place, and the ownership of creator is him. The copyright gives creation ownership the moment you create it. Registration, remember, is not available in Sri Lanka, and it's not a must. Even the countries that is available, it's only a date stamp from the day. It is not proof of authentication. All right. So the other thing is, I'm rushing through things, but in question time I might elaborate if you want more. The other thing you have to remember is about most questions that are come up is regard to playing original content created by someone else on an online platform. For this content could be anything. That could be reading a book that is belong to somebody, or online, going on Facebook or something, or playing a music in the background of your video. These things are restricted because if you buy a book from a shop, you are supposed to read it, but you are not supposed to be reading it online to some other audience which you might create, right? Same with the blog post, or same with playing a music, except for the fact that the doctrine of fair use will come into play for you to give exception if you are teaching. And these days, we know during the COVID-19 period, there were a lot of online teaching that was happening. So if it is teaching or news reporting or training purpose, that exception is there. And the other thing is especially about music. Now, a lot of people, most of us might buy CDs and cassettes and legitimately buy them, not illegally download, or we might download the tunes from iTunes or something like that nowadays. And we will think that we have the right to use that music because we paid and bought it, to upload with some other visuals or somebody wants, or upload in a site that we create, a YouTube site or something like that. Now remember, most of the time when especially if you buy a physical CD somewhere down the line, or physical product, you don't get the digital right most of the time, digital rights to re-upload on a online digital platform. And even if you download from iTunes, unless you specifically buy that, you don't have. So you will be violating the copyright and the performance rights of those owners, unless you have got those rights, whether you are streaming it or you're re-uploading with other visuals or not. And that is why you see most of the time Facebook or YouTube, all these stations, mute them and forewarn them before muting that there could be even further actions if you continue to this. And one of the examples is, I know a particular television station which I advised, and their producers were taking tunes from other products, other creators, and those tunes were used only parts of it to create their own television programs, only parts of it. So somebody can say this is fair use, but when they are, after they broadcast, when they upload to their own YouTube site, the YouTube sites and the Facebook sites of theirs continuously advise them, don't do this, and they went to the extent of shutting down that YouTube site because they are continuously violating other people's tunes and music. Now they argued about the fair use content because it didn't come across the fair use coverage, for the reason that it was a commercial product which they create out of somebody's using somebody's part of somebody's tune to their own program. So commercial product does not, fair use does not cover commercial product. In addition to okay, the other thing, main issue is happens is when you are live streaming from sports events and music events. This probably doesn't happen much in Sri Lanka, but it happens across the globe. People go to sports events and music events and stream live, sometimes try to stream live the whole concert on Facebook or YouTube or something like that. Now remember, this is completely illegal. You cannot simply do that, because if you're going to a music concert, you can't do that at all, because the venue owner has not cleared you digital rights for the audience who comes, who they sell tickets to live stream. They have only got cleared the rights from the singer, the performer, the copyright owner, the producers of those music whatever concert to play there, and that's all. So you cannot go and stream live a music concert in a place like that. But it also applies to certain amount of sports, type of sports, which are considered in international copyright law as creations or a work, which is the sports in the nature of figure skating, synchronized swimming, and gymnastic and ballet. Now these are under sports, in the sports law also, international sports law. They are categorized as aesthetic sports. That means it qualifies to a work of art, a created work of art with authenticity under copyright law. But now you cannot simply, in a concert or a sporting event of such nature, figure skating, synchronized swimming, gymnastic or ballet, some examples like that, created a product, you can't go and live stream from there also. That is one area. But there is an exception to that. You might be surprised a little bit to understand the other major sports, all other major sports, cricket, football, hockey, tennis, rugby, everything, which are considered in sports law as purposive sports, they do not have a copyright on that event. Yes, this is very true. So the copyright is there only for the people who take that rights on television and broadcasts, but the event per se does not have a copyright. So tomorrow, if you go for a cricket game or some kind of a game, not tomorrow after COVID restrictions are over, if we go and if you try to stream live from there, nobody can stop you from doing that. There are ways to stop you from doing that, because if you violate the ticket conditions, but there is no infringement of copyright there. But if you hold that phone or whatever device you want to streamline into a screen which is telecasting that sports event, then you are violating that person's broadcasting right. It can be couched under signal theft as well. So there's a little bit of a distinction there. Since we are almost coming to, I think I'm getting warning about the timing. I do have a lot to touch upon. I will answer in the question and answer time. With regard to during the COVID-19 period, as we know, we had one of the things we did was online conferencing, and online conferencing, one of the complaints that are keep on coming now is loss of corporate secrets, confidential sensitive information, etc. I'm sure speakers after me will touch upon that. That's largely data protection issues. We'll touch upon that. But other important things I need to take you through is the other big issue that has come on social media and online digital platforms about hate speech. Now, a lot of people don't know that there is a hate speech law in Sri Lanka also that makes hate speech an offense. Section 3 of the ICCPR Act, that is the International Covenant on Civil and Political Rights Act, says no person shall propagate war or advocate national, racial, or religious hatred that constitute incitement or discrimination, hostility, or violence. So the key word here, it is not only, doesn't have to go to the extent of propagating war, but advocate means says anything to incite discrimination, hostility, or violence. Now, even if you attempt this or abate this or commits this or try to commit, there is it's a criminal offense. Remember, it's non-bailable, and unless by High Court, and prison term can go up to 10 years. So it is all what you say, and this ICCPR Act is in sync with Article 20 of the International Covenant of Civil and Political Rights Convention. And there's a test that is created, which was circulated by a circular by the Human Rights Commission of Sri Lanka recently on request. I think the test, what you have to understand, the crucial factor in determining what is hate speech is, remember now, this is not meant for digital platforms. This is meant for across the board. So whether you do it digital platform or otherwise, it is the same. Hate speech is hate speech. The crucial factor determines hate speech is a person who incites others to discrimination, hostility, or violence, intending not only to share his or her opinions with others, but also to compel others to commit those actions based on his beliefs, opinions, and positions. So anything that is provocative nature, the nature of the argument, the mode of expression used, tone used, expression, all matters. Also, remember, this is the key when it comes to, this part is key when it comes to digital platforms. The reach of the advocacy, whatever that kind of nature of things you have propagated, the reach, the public nature, the magnitude, and the size of the audience. So if somebody is having 10 million Facebook likes or comments or friends, 5,000 friends, whatever, the more you reach, and so you're reaching to more people. So if you have more connections to your particular platform, your possibility of getting considering it as a hate speech is more. And also the reasonable probability of what you say is going to incite, cause imminent. This leads to, I think, many governments across the globe to curtail social media. If you can remember, soon after these attacks here, the Digan event in 2018, and also in the US, the Black Lives Matters issue, which came 2 months ago, digital platforms were misused and people did post things which came in the nature of hate speech. So whether you're doing it just on the road or by post or whatever, or by social media or platform, hate speech is hate speech. So I'm going to stop here. I think, I'm going to stop here. There's other areas, lots of areas like defamation and everything that can happen on digital platforms, which probably I'll touch upon if you have a question on that. Thank you.
Thank you. Yeah, thank you very much, Mr. Jayadeva, for that analysis of how intermediary platforms or third-party platforms that people use to connect, and what are the key issues in the IP area that comes up, and what is fair use. You analyze that, and as well as you touched upon the issue of hate speech on third-party intermediary platforms, and what is the law in the country and how it should be interpreted. I will now move on to Ms. Sandhuni Vikramasinghe, who will take us through the data protection privacy issues that are being discussed globally as well as in Sri Lanka right now, and what it entails in the Sri Lankan context. She will also touch upon the business use of such data protection law and how it can best serve everyone in our community.
Thanks, Anurag. During the course of the next 10 minutes, I'll try to cover as much as possible with regards to data protection in relation to the online platforms. But before we get into the nitty-gritties, I think it's better we try to identify the relationship between privacy and data protection at the very outset. Because sometimes we find that these two terms are used sometimes interchangeably or in conjunction with each other, but there is a fine difference between the two. Because if you look at privacy, has been recognized as a human right in international instruments like the UDH, United Nations Declaration of Human Rights, and Article 12 and Article 17 of the ICCPR. So in both of these conventions, you would see that privacy is being characterized as both as a positive right as well as a negative right. In one sense, it requires governments to refrain from arbitrarily interfering with someone's privacy, their correspondence, and so on. So as you know, and the thing about privacy is that there are different connotations, and information privacy is only one aspect of the whole umbrella concept of privacy. And from a negative right point of view, from a positive right point of view, it requires governments to safeguard safeguard people from unlawful interference of their privacy. And this is where data protection laws come into action. So you would see there are several ways someone's right can be protected, whether you are recognizing it as a right in a constitution or by common law principles or by giving a statutory right. So you have instruments like cybersecurity laws or data protection laws, which act as the means to achieve that right of privacy. So how I find data protection, the relationship between data protection and privacy, is that the data protection principles are the means to achieving that notion of privacy. The notion of privacy being, you being in control of the information that is about you, that is disseminated, so putting you in control. And a data protection law is essentially intended to address that issue of putting you in control of your information. And so one thing to know about a right to privacy is that it's not an absolute right. You will always find other rights that are competing against it. So if you look at my little scale here, so you would see you have data protection and privacy on one hand, and you have other concerns and considerations like national security, right to information, using information for criminal investigations, and health and safety measures are being taken on the other side. So given that this is not an absolute right, you need to have that balancing act to ensure that you reconcile the competing interests. So this is not to say that privacy should always trump over the others, or for example, national security must trump in every given circumstance. What is important is that you reconcile the competing interests in such a way so that you get a win-win situation. I mean, it's easier said than done, obviously, and one of the methodologies you could use is the Syracusa Principles. For those who are familiar with it, is where derogations of rights in the ICCPR where the derogations must be prescribed by law, and it should be necessary and proportionate to the aims of national security and health and safety, and so many. There are several other considerations to be balanced off. So as long as the competing interest is something that is prescribed by law and is proportionate to the aim you pursue, then you could have a reasonable balance between these competing rights. So if we look at, take certain examples like I think one of the most recent example that we are all familiar with is the COVID experience, where you have the health authorities, trying to engage in contact tracing that tends to be an infringement on the privacy of individuals. So what is important here is that while you have to balance the public safety and health concerns and everything on one side, you need to see whether the measures you're taking are proportionate to the aim you pursue. So this is where, again, data protection principles come into action. And if you take, for example, now one of a common example is like we find most people switching to messaging platforms like WhatsApp or Telegram because they perceive their information, they want their information to be secure, they want that safeguarding of their communications. But then on the other hand, we have criminal enforcement authorities who wants to find culprits of offenses and ensure national security. So whether it's okay to engage in mechanisms like mass surveillance is all right, or whether that amounts something disproportionate effort on the part of the government are things that you need to look at when you're trying to reconcile privacy and data protection against other competing interests. And so this is not just limits itself to governments. I mean, if you look at so many private platforms, if you so this is a cartoon I often like to use, where you have all these free platforms which we love to use, and we always think that it's great to use this free stuff because we don't have to pay for anything. But those free things comes with a cost, because there's a famous quote among privacy professionals that if something is free, you're not the customer, but you're the product being sold. So it applies to in certain instances, and you saw an explosion of that situation in the Cambridge Analytica situation, where this app tend to harvest information off Facebook against your knowledge or will, and try to nudge you in certain decision-making situations, or nudge you towards in a certain direction. So, I mean, it's too. I mean, I can go on with so many examples in everyday life, but so these are some of the key examples I can pinpoint to direct your attention to the fact that how to balance data protection and privacy principles against other competing interests. And so essentially, if you're moving on to a data protection law, I would see that it address two key aspects, one being the from a business aspect, how it affects businesses and how it affects individuals. So trust here, why I put it in all capital, is because one of the key components in these digital economies. So if you consider data to be the new oil in an economy right now, I would consider consumer trust to be the currency that runs it. If you don't have trust, if the people don't trust in your services or your product, and if people think that you're doing shady business with their personal information, you lose that market share, you lose that revenue and everything from in your business. So it's important that you build your trust, build the trust of your customers by adopting these good data governance principles and data protection principles. And it also facilitates innovation as well as cross-border expansion of business, because you see, like, across within the region as well as across other countries, how companies, how regimes have always required the need of having proper data protection laws. I mean, with the GDPR coming into effect, which had a rippling effect across the globe, I would say there has been increased requirement from governments to ensure privacy of their citizens. And from so this impacts businesses even in Sri Lanka. So if you're looking to do businesses with the European counterparty, then your European counterparty would require you to be either GDPR compliant, or they would look at what the sort of legal regime in Sri Lanka that would ensure whether it's comparable to GDPR, or whether that legal regime affords reasonable protection. So from an individual point of view, I think data protection laws gives a certain array of rights to individuals to either to give consent or withdraw consent, to have access to their information or to have it corrected, and if it's obsolete, to have them erased, and to hold people who process your information accountable to their processing activities, as well as be informed about data breach notifications. And so these are things that thus far has not been covered by existing legal principles. Either they do not cover it at all, or they tend to do it insufficiently. So you would find that the proposed data protection bill tries to cater to these requirements by putting the individual back on track and putting that individual in control of his or her information. And that's a roundup.
Thank you very much, Sanduni, for that uh, taking us through the issue of data protection vis-a-vis privacy and how data protection is the way forward in achieving the gold standard of privacy and how we are going to do that. And also, we appreciate very much of taking us through the importance and the business value that data protection and the proposed legislation uh, would bring to our ecosystem. Now we move on to Mr. Jayanta Fernando uh, to take us through the issue of security and safety of people online. Uh, Over to you, Mr. Fernando.
Thank you, Senora. Am I heard clearly?
We can hear you.
Okay. So thank you very much. I thank the Bar Association and its committees for taking the initiative to organize sessions of this nature to enlighten and perhaps update awareness about some of the latest things that are happening. So Senora, I think before I go into the pure security angle, there are a couple of things I just want to highlight. So firstly, I thought we need to emphasize the fact that Sri Lanka is gradually transforming itself into a digitally empowered nation, right? One impact of COVID, which the technology community is looking at from a positive angle, is the fact that the number of usage, number of accounts, number of subscriptions, including the dormant smartphones, which are in the range of about although we have about 52% usage of smartphones, roughly only about 30-35% are actually being used. But I think gradually we could see a rise in this number in recent times due to the COVID situation, where work from home, working remotely became the new normal. And it is encouraging to see that the Bar Association and all of us are doing this program online, which is also a unique experience. So in that context, we can see many laws, many statutory frameworks, policies are already in place to enable that to be more effective. So for example, one of the baseline laws we need to remember is that we have a very strong telecommunications legal framework, although it's a fairly archaic law that needs to be modernized. We nevertheless have a strong regulatory environment for interconnection and fixing prices and tariffs. And despite the taxation, we can see the data and connectivity costs perhaps maybe one of the lowest in the region, which people should be aware of and should be incentivized to use technology more and more in their day-to-day life. And I'm looking forward to seeing, hopefully, the legal community taking this COVID experience to the next level by going into the digital courts, virtual courts environment. And I'm happy to see many of us using those platforms for online, maybe legal resolution of matters. And in that context, we should remember that the electronic transactions, the amended Electronic Transactions Act Section 2 has got provisions thereby digital filing of documents, etc., can be done electronically, digitally, maybe even using digital platforms. So I'm looking forward to a day where using social media platforms, one could submit documents, written submissions, pleadings electronically, and that is enabled under the amended Electronic Transactions Act, and the courts are able to make rules governing the procedure relating to same. Now, Having said that, my previous speakers, especially Chanakya, very clearly articulated the challenges in relation to the digital platforms, hate speech, disinformation, fake news, and so on and so forth. In that context, we must remember that gathering electronic evidence is a significant problem that we need to deal with, and as practitioners, we need to confront these aspects, whether it is a civil matter or a criminal proceeding. And in that light, we should be mindful of the fact that electronic evidence in the digital media, especially in the context of the digital platforms that we are using, can be in multiple jurisdictions. So how does one get access to electronic evidence on a real-time basis? And what are the available tools in that connection? So there's a growing international discussion around this area, especially in the United Nations, about the need for a new set of norms through the UN treaty-making process to harmonize legislation on cybersecurity and cybercrime. What we should be aware is that at this moment in time, we have an international instrument called the Budapest Cybercrime Convention, and Sri Lanka became the first country in South Asia to become a state party to that convention that enables our criminal justice authorities to gather electronic evidence from multiple sources and multiple jurisdictions, including to carry out interceptions and real-time evidence gathering. So, for example, if you look at Section 18 of the Computer Crimes Act number 24 of 2007, we have the provisions for the domestic production order where subscribed information and traffic data relating to a particular event or a session or a transaction can be obtained through a court order. So that is some example I want to cite. So moving on to cybersecurity, the pure aspects of cybersecurity, one of the challenges in the digital platform and digital media that we face on a regular basis is the fact that governments, businesses, individuals are all affected when it comes to aspects of cybersecurity. As a country, as a society becomes mature in the digital communications media, and I think we have, at least Senura can confirm the number of Facebook users, maybe we have about 4 to 6 million range of Facebook users. In that context, issues of vulnerabilities, threats affect not only individuals, but governments and businesses. So in that context, the government, especially one of the organizations with which we are involved, Sri Lanka CERT, developed a cybersecurity strategy. This cybersecurity strategy is available online through cert.gov.lk website, and I would urge you to look at it. It has 6 different pillars, and I will not go through each one of them, but suffice to say that under pillar 2, which is a thrust area of the cybersecurity strategy, the legal environment is being planned to be reviewed in a 5-year window. It is in that context that we got a mandate to embark on the review of legislation governing data protection that my colleague Sanduni explained in brief. We can take Q&A connected with that later. But side by side with the data protection bill, we also drafted the cyber security legislation. So if you look at the objectives of the cybersecurity draft bill, which is pending enactment by Parliament, the primary objective is to ensure effective implementation of the cybersecurity strategy, which I explained in a moment ago. Secondly, to prevent, mitigate, and respond to cybersecurity threats, incidents effectively and efficiently. And thirdly, fourthly, to prevent, to ensure, to provide for a safe and secure cybersecurity environment, and then also to set up a cybersecurity agency. And last of all, one of the key objectives is to protect critical information infrastructure. So for example, all of us, we are using the Zoom platform today. We are connected through Mobitel, Blankabel, Dialog, XLT platforms. All of them are critical information infrastructure which we are using at this moment in time. And look at our electricity network provided by either LECO or CEB, depending on where you're living. The distribution of electricity at this moment in time is managed efficiently. The power distribution is managed efficiently and effectively through a SCADA digital system. So that would become a critical information infrastructure from the perspective of the cybersecurity law. So all these infrastructures we are having in the country has to be protected and safeguarded with basic minimum standards. And it is in that context that this cybersecurity law will become an essential tool to set the governing institutional framework as well as the standards that the critical information that our services are actually provided without any disruption. So in that context, only the cybersecurity legislation and the norms governing this subject area has evolved. There are intricacies related to this subject area that I may like to discuss in more detail, Seruna, but I think at this moment in time, I will leave it with this broad introduction, and let's take a Q&A. And during the Q&A, I'll be pleased to go into any of the details that we discussed in this short introductory session. Thank you.
Thank you very much, Mr. Fernando, for that great introductory remarks on our cybersecurity policy. What is the infrastructure that we are going to put in place to keep our communities safe on the site, who use third-party platforms to connect in the site through the internet. So we are done with the initial presentations of our panelists, and now we would move on to the Q&As. So we got 2 questions which I would pose to Mr. Abhiratna as well as Mr. Fernando, because these 2 questions, the first question pertains to electronic evidence and whether how SMS or MMS or email evidence can be presented in a divorce case or in non-commercial matters. I would invite both of you to take a few minutes each and address that particular question. Thank you.
Yeah. Can I answer that question?
Yes, please. Yes, sir.
Now, basically, Section 21 of Electronic Transactions Act, number 19 of 2006, governs the provisions relevant to your question. Now, 21.1 proviso that we have to carefully read this proviso with Section 21.1 and 2A and B. Now, Section 21.2b says the compiled, received, or obtained during the course of any business, trade, or profession, or other regularly conducted activity. If your divorce matter, that evidence relating to divorce matter comes under any business, trade, profession, or other regularly conducted activity, yes, you can produce this evidence under Electronic Transactions Act. It is so simple according to the provisions under Section 21. But if your client has gathered this evidence not under any business, trade, or profession, or any other regular conducted activity, then you can't apply Electronic Transactions Act. Of course, I will take example. If a company chairman and a correspondent, if they have transpired some emails during that transaction, it's transpired about some unlawful connection, then sometimes you may be in a position to bring those evidence under regularly conducted activity. Otherwise, it is very difficult to bring the evidence under this act. Then you have to apply Evidence Special Provisions Act for that purpose. So these are the main requirements. This is the efficiency of a lawyer to declare and whether your evidence comes under E-Transactions Act, especially whether it comes under Section 21(2)(b) or not. Then, accordingly, you have to select whether to apply E-Transactions Act or Evidence Special Provisions Act.
Thank you, Mr. Aviratna. Mr. Fernando, I'm going to connect that with another question that is one of our participants has asked.
Yeah. Can I respond to that also?
Yeah. Okay.
Yeah. So basically, thank you, Sunil, for that clarification, which I think clearly sets out the provisions under which one can rely on that kind of evidence. But I think, if I remember right, somebody, the question was in relation to divorce proceedings, right? Whether that evidence can be used in relation to divorce proceedings.
Non-commercial.
Yeah, non-commercial. So of course we know the Marine Star case and few other connected cases now in the Court of Appeal, especially in 2017 and 18. One of, I think, Justice Surasena and two decisions of delivered by Honorable Justice Kamini Amarasekara that clarifies the scope of use of the Electronic Transactions Act in relation to electronic evidence admissibility. Having said that, I think something interesting that we might like to remember is the fact that the famous Civil Appellate High Court case of Galage Prabhat Piris versus Jacqueline Afonso, the Civil Appellate High Court judgment was delivered on the 11th of July 2014. And basically, in that case, they examined the various provisions of law, especially the scope of application of the Electronic Transactions Act. And the lawyer for the defendant took a preliminary objection on the basis that, well, even if that evidence can be used, that it was not admissible under the Electronic Transactions Act, because the scope and ambit of the Electronic Transactions Act was in relation to trade commerce business. And they interestingly looked at some of our original paperwork that was filed in the Parliament when the Electronic Transactions Act was debated between 5th and the 6th of March 2006. So what happened was that in those debates, it has been brought out that the provisions of the Electronic Transactions Act are founded on the ancestral model law, and it related to trade commerce business. And therefore, this law, the Electronic Transactions Act, was purely for that purpose, and so on and so forth. And therefore, that the divorce proceedings were not of a commercial nature. So therefore, they said that the Electronic Transactions Act would not be applicable, which would mean that one would have to give notice and go through the Evidence Special Provisions Act. So in that kind of a drawback situation, I would think that it might be useful to look at the provisions contained in Section 9 of the Evidence Special Provisions Act, which enables, which has a which has certain degree of discretion given to court using a presumption of law that can be widely used. And I would think that that provision read with Section 3, the casus omissus section, can be read together to conjoin an argument with regard to the manner in which one can admit this kind of evidence based on some kind of regularity of business kind of transactional detail that can be obtained through a platform service, and so on and so forth. So there are ways of arguing it, and let's go into those details later. Thank you, Senator.
Senator, to add to Mr. Jayantha Fernando's that explanation, now take section 23. Section 23 of the Act explain the restriction on application of the. Now, what happened was the Dalage Prabhat case and other case decided before a civil appellate high court, they excluded all non-commercial matters. Then the question arises, when the legislature excluded subject matters under section 23 of this act, can the judiciary also exclude some items? Now, the Justice Randaranaga's judgment is very clear that the judiciary is not there to create laws. It is the duty of the legislature. Legislature has already excluded subject matter. So, on the other hand, when you look at section 21 2B, the regularly conducted activities, whether it's a commercial or non-commercial, it comes under this act. The problem is, when you look at E-Transactions Act, we can see the part of electronic commerce and Untitled Model Law and various other statutes from other countries, and e-governance, admissibility of evidence. The three parts are in only now E-Transactions Act. On the other hand, there is no definition given for e-transaction under our act. So these are the practical problems in future that when we go for the new reforms, that we have to think about this matter.
Thank you very much, Mr. Fernando and Mr. Abhiratna, for that clarification. I would like to just move on to Mr. Jayadeva now and pose him this question on content that is posted online on third-party platforms and the issue of defamation. As in, there are many questions that have been raised on the liability aspect. What are the salient issues that crop up? Mr. Jayadeva, could you elaborate?
What is exactly the question? Are you
on the
referring
issue,
to this
third-party platforms? Yeah, issue of defamation on third-party platforms.
Right. I think the question is, what is the remedy available to remove defamatory post on Facebook when company logo is used?
Or
is that...
for that matter, like any third-party intermediate platform, be it Twitter, Facebook, Instagram, or YouTube, or whatever.
Yeah. The thing is, it is not clear in most of the sites whether when you complain of a violation of a copyright, generally, as long as you can prove your authentication, not only your date stamp of registration, but your authentication, most digital platform sites tend to remove. They remove it by warning the person who has posted them to remove it. Otherwise, they take it down. It happens whether it's a music or anything like that. In defamation, what the problem I think we are facing is these sites. Most of these platforms are held in countries where the law is different to ours, and defamation is a very difficult thing to prove on those countries, because of the freedom of expression has taken such a leap, and most things that are said defamatory is very difficult to prove. Because of that, unless there's you make a real case, most digital platforms are reluctant to remove defamatory material as opposed to copyright infringement material. But what you can do is, now that is how you deal with the platforms and the ISPs, and because most of these people are these companies are in the United States and it's subject to their law or European countries. But you can file action here in Sri Lanka for your defamatory material, and if you can make those institutions parties, because they are intruding into not intruding, I would say they are in our digital space where it can be seen by Sri Lankans. And see, to make something defamatory, it has to have repeated, not just one saying, repetition of that defamatory statement, and it has to fall out of the exceptions of truth, justification, or fair comment. So as long as those general things can be proved, the person against whom the defamatory action has been posted or streamed or uploaded, action can be filed in district court as a damages case. And if that person is in Sri Lanka, obviously judgment can be served on that person. But if the person is abroad, we'll have to serve judgment in that country depending on the arrangements Sri Lanka has with that particular country, whether we have a reciprocal judgment order, enforcement, reciprocal judgment enforcement treaties or not. It depends on that. I think Sri Lanka has a few countries and not most countries, in which case you can enforce that judgment. And the other thing is, of course, if that person is living abroad and it will cost money, you can go to that particular country and file. I know cases I have advised, and there have been cases like that with very prominent celebrities whose defamatory material were on social platforms. I cannot tell you the names. I will just say the region. It's India, but not the places. But they had found that there were defamatory material published on them on one or two of these major digital platforms, and they found that their country does not have reciprocal judgment enforcement with the countries in which the people were living in. So they had money, so they went to those countries, filed, prove, and because of they could prove because of their celebrity or status, and damages were offered. And I think halfway through, most of the one or two of those cases, halfway through they settled. With the case is bad. That's that. And the only other point, I think I was talking to Sendra also about this yesterday, that if these defamatory material were on a local broadcast, a traditional radio or television broadcast, which lots of cases were there, especially the last 20-30 years, they become liable as a carrier. They make a party. But it is not the same position that YouTube and Facebook and most of the digital platforms take, because they're not subject to our law and they are subject to the US law, and they don't become a carrier. But if we do make, for the purpose of proving, we will have to make them a party, whether they become secondary liable as a carrier or not. That's it. And there was a part on that question, I think, asking what CERT can do. I don't know answer, but I don't know whether Jayanta can answer on that part in a situation like that. Jayanta, can you pick up from there?
Yeah, sorry, what was the question, Senura and Chanakya?
What is the remedy available to remove defamatory post in Facebook, or when a company logo or is also used? It is basically defamatory material, and how can CERT help such situations?
Yeah, so as I think I just briefly mentioned in my introduction, CERT is not a regulatory or an investigative body. It is a cyber threat management, mitigation, prevention organization. So it is there to do vulnerabilities, address cybersecurity threats, incidents, and respond to wrongful behavior, not in the context of the masses in general, to help the general digital environment function in an effective way, so that we can all use our technologies effectively. So there's a bit of a misunderstanding about the Sri Lanka CERT mandate. It's mainly supporting government, businesses, and other organizations to have a secure environment. However, I am mindful of the fact that traditionally, due to the lack of any other organization, many individuals who are affected by Facebook kind of social media abuse incidents and other defacements, including defamation related matters, end up at Sri Lanka CERT. So what Sri Lanka CERT has traditionally been doing is perhaps make the individuals and organizations who are impacted by such defamatory or even a trademark infringement or some such matter, about the remedy that is available and how they should contact the platform providers directly. And maybe I think I would put this back to Senura, who would be able to better respond, especially since the Digana incident. The government took steps to develop strong linkages with platform providers like Google, Facebook, and other providers. And in response to that, we are pleased to say that we have had a proactive response from organizations like Facebook, which is represented by Senura, And very often when matters are brought to their attention, even by individuals and organizations directly, they would respond based on their community standards and guidelines as to how a matter can be addressed, including a defamatory post, how the matter can be addressed. And in that context, I'm mindful of the fact that organizations like Facebook and Google and many entities respect the decisions, even interim decisions, orders given by courts of law in Sri Lanka. And they have been very responsive, especially over the last 2 years. So maybe Senura can explain a bit about how they respond to defamatory posts and the means of taking down posts.
Senura, before you respond, I think what I'm going to say, it might, because I need a response as well from you. Now, one of the things, elements to prove in defamation is publication. Now, when this is post, if a post, if a defamatory material goes on printed, the print media is considered. It is considered public publication. So is the traditional broadcasting media. Now, if it is not printed or on the traditional broadcasting media, I mean, a Facebook site of a television channel is different. But if it's only on the on one of the online platforms repeatedly take the position they are not publishers because they don't have editorial rights. So we will have a problem there on proving that because they I think Facebook take the stance that they don't have they are not a publisher. So then was this published or not question comes in a defamation, which is an essential element to be proved. But in reality, we'll say if it was published on a person's site, which has 1 million, 2 million likes, it has gone to so many millions of people. The de facto publication has happened. It has been, publication means communication to the people. It has happened. But the online platforms says they are not publishers. So can you, in your answer, can you answer this as well, Sedro?
Yeah, I think the position, I'll be very, very clear here. The position across platforms is the same, right? Because that's how the platform structure, that whole ecosystem is developed based on the Communications Decency Act of the US, because most of these platforms are US companies and they are subject to US law. But as these companies grew across beyond the borders of the US, they also took up the position that they would comply with local law as long as there is a valid court order saying that there is a breach of the law of that country. It's as simple as that. Now, with respect to the issue of publisher versus intermediary, on the issue of like a publisher, like when you take the case of a newspaper or a TV channel or a radio broadcasting channel, they curate the content. Those organizations curate the content. Journalists go find the story, write the article, and they publish. That is publication. The main distinction between that type of content and the content posted, shared, streamed online on third-party platforms is they are user-generated content. The company does not sit there and curate content of 2 billion, 3 billion people. It doesn't happen. That's not how the user creates the content. So that is the fundamental distinction between a traditional media organ and the third-party intermediaries, which enables users to express themselves. So that is, I think, a fundamental distinction, and that makes it very, very clear as to why the intermediaries are not publishers. Hence, that solves all the other following questions. Yeah.
To add to your answer, intermediaries' liabilities is developing, and there are series of judgments. The recent judgments are available. Now, take example that L'Oreal's case recently. It went up to the position that that court can grant interim injunction even without praying the permanent injunction against eBay. So we can. There are some examples that the system is developing. I think now intermediaries' liabilities. It's more powerful at the moment.
So even that's
sorry, go
is
ahead.
provided for by law. That's my what I'm trying to say here. Like if you look at Indian IT Act, the IT Act provides for rules and regulations for to govern intermediaries. Similarly, in other jurisdictions, all intermediaries can be held accountable, and for that, intermediaries companies cannot make law for countries. It is the governments who have to make the correct legislation to address these issues. And this is the position articulated by all of the companies on this type of content issues.
Yeah, so Senora can up on the pending laws. Yeah, Senora?
I'm sorry, sir, I didn't hear you.
Yeah. Based on what you just said, can I take it straight to some of the pending laws that have been discussed in recent times? Maybe I just give a quick snapshot, which we didn't address earlier. So based on the necessity for laws to address these kinds of issues in a very challenging environment, as Senora explained, just I think not only just after post Digana, starting from post Digana, post Easter Sunday, and the scenarios that we encountered as a country, there has been an effort by the Ministry of Justice and Ministry of Media and Communications to sit together and ramp up efforts to formulate certain laws. So what I think we must be aware is that the Legal Draftsman's Department has finalized, as of end of last year, amendment to the Penal Code with regard to hate speech, disinformation, and I think there is a provision including what would amount to fake news, coupled with an amendment to the Criminal Procedure Code Act that would permit courts to issue takedown of posts, takedown of posts that would amount to disinformation, that would constitute hate speech, and posts that would amount to even disinformation. So I think that area is an evolving subject, and we need to be mindful of the fact that many government entities have worked together to formulate laws, and I think there is a need for more public discussion of those so that we are all aware of the relief measures that would eventually come through by invoking the proposed amendment to the Code of Criminal Procedure Code Act by using the takedown and even provision requiring platform services to carry out appropriate corrections. So Senora, perhaps that is helpful and give you all the mechanism to address the challenges that we have from countries and communities at large, right?
Yes.
Jayant, I have a question for Jayant. Can I pose it? Can I ask it? Jayant, you mentioned about Budapest Cyber Convention, and we are a signatory. Is it? Have we made domestic legislation? As you know, I mean, we are a dualist country. We have to make domestic legislation for its enforcement here. Have we made that, or have we only taken parts of that and inserted in our laws? What is the position there?
Well, I think the latter is the appropriate approach, and basically one might look at certain amendments because basically the Budapest Cybercrime Convention is an instrument for mutual legal assistance, for expedited mutual legal assistance in gathering electronic evidence expeditiously. So in that context, there was an amendment to the Mutual Legal Assistance in Criminal Matters Act a couple of years ago, and regulation was brought in under Section 2 of that Act, whereby the provisions of the Cybercrime Convention can be invoked on the basis of the fundamental principles of reciprocity vis-a-vis all our countries. So the state parties to the Budapest Cybercrime Convention have been listed out in that Gazette notification, and both our law enforcement agencies and the law enforcement agencies of our counterpart countries can both benefit from a series of measures, including undertaking joint investigations and sharing of spontaneous information under Article 26 of the Budapest Cybercrime Convention. But I think on that specific issue that I think I can see several questions being posted, I was seeking a clarification from Senura whether the provisions, if there's a possible amendment to the penal code relating to disinformation, hate speech, along with a takedown correction kind of a procedure through an amendment to the Code of Criminal Procedure Code Act as proposed by the Ministry of Justice, whether that would address the problem. And I think Senura was trying to reply that. Senura, can you just clarify that?
So I'm very mindful of the time. I think we've just gone over it, so I'll just keep it very short. So there is a proposal by the government regarding how this type of content should be treated. I think things would be re-looked at when the new government after the election would consider these aspects, as I understand. But as proposed, the early stage legislation, I think, proposed legislation rather, that is being discussed, I think, across ministries on this issue. So I'm not sure whether I would like to go into the details at this stage, because this is something that the government is considering at this time. But just to set out like the position of, let's say, Facebook, is that any type of regulation in this regard has to come from the government, and that has to be the mechanism that we have to work with. So just before we conclude, there is one last question, and that question is to Sandhuni. The question to you is that there's often criticism that data protection regimes hinders business or like holds back growth. What is your response to that?
Thanks, Sarah. I think that's an excellent question to ask at this point, because one of the, as you rightly pointed out, it is a criticism that we get from certain quarters that this hinders innovation, and this adds more effort on the part of startups and other small scale companies to when it comes to compliance. So, but the thing is, like I said earlier, when you look at businesses, if you're processing personal data, and the value of your business comes from the consumer trust. So the more you trust, when the consumers trust your services or your products, then it adds value to your business. And this has, if you look at around the world, not just in Sri Lanka, but with the advent of data protection laws, including the EU regulation in this regard, has actually spurred businesses to be more privacy mindful, and be more to design their systems in a manner that enshrines this data protection and privacy principles. In doing so, they have become more accountable and more transparent in their business dealings. So this has actually led to more innovative offerings to the general public, because as you can see, there is a host of people, the public in general wants to adopt services that seems to be secure in their offering, and so there is a significant market who wants this sort of services. And in order to address that, I think businesses can find themselves in a good position if they can conform to these data protection principles or privacy by design principles and so on. And I think it's a misnomer to say that this discourages businesses, but actually it also opens if you're in conformity to data protection principles, it actually opens yourselves to more interactions with international counterparts, so to speak, like European companies or Singaporean, where those jurisdictions seek adequate protection of personal information in other countries. So I think there is a lot of potential for businesses to gain from having a data protection law as opposed to having none.
Yeah, so Sandhani, if I just may ask sort of follow-up question on that, like how do you distinguish between like mature economies which are GDPR compliant as opposed to like companies which are like countries which are not that mature and are developing or less developing countries?
So the thing, so there's a related concern here where whether Sri Lanka is is ready to embrace the data protection law at this time. But one thing the committee always thinks that we are just at least 10 years late to coming into this discussion. But regardless of the fact that how mature of certain economies in terms of data protection, there's no limitation for a legal regime to be introduced. And maybe even one thing I've noticed when the EU GDPR came into effect 2 years ago, there were a host of businesses, even in the EU, who didn't really understand the gravity of that law, and and had were in this flux of worrying about being in compliance with the GDPR. So I think it's more of it's how each company approaches their compliance obligations and having a clear understanding of which sort of laws apply to their business, and having the clear grasp of the legal principles that applies to them. Because if you go on a misguided notion, then you would find any law to be too cumbersome to comply with. So therefore, I think it's because digital economies and globalization is a thing that is not going to stop. It's going to continue, and will bring economies closer together. So in doing so, you need to have laws like this that supports things like cross-border data transfers. And so the importance is that you understand your exact legal requirements and then manage your business accordingly.
Sandhani, if I may pose one last connecting probably question. Now, the draft legislation which you are going to, which is ready as a bill, is it completely in sync with the international GDPR and other data protection laws? That is one question. The other one is, how does the data protection, has it made exception in extraneous situations like COVID-19? Now, worldwide, governments, hospital, medical services needed for contact tracing your very personal details, which personal details are at the moment under the even the Right to Information Act curtails taking those things. I'm talking of medical records. Now, is there a provision under data protection international laws to lift the veil of protection in situations like that?
So thank you, Chanakya, for that really insightful question. So in terms of about the data protection draft bill, rather, it's still not an official bill. So it's still in draft stage. So we have looked at principally at the OECD principles, which we considered as a good norm of data protection laws. And we've looked at, given that the European Data Protection Regulation is the most mature in terms of implementation, we've looked at those principles as well, but we avoided ourselves from having a carbon copy of the GDPR, because we've seen how jurisdictions who have adopted in word to word, which are non-European member states, they find it difficult in terms of implementation, like countries like Mauritius, for example. And you will see there are certain differences from GDPR and the bill which we have, which is currently in circulation, is where we try to tweak things which are amenable to the Sri Lankan requirement. And you would see that things like we have selective data localization, that is requiring data to be in Sri Lanka, such as data processed by government ministries and so on, because that is coming from more of a data sovereignty point of view. And something like that you would not necessarily find expressively in the GDPR. And things like having no difference between manually held data and digitally held data. And one of the stark differences, if you look at things like Singapore laws and from Singaporean law, is that where we have tried to include both data processing of governments as well as private sector. I think from that we've looked at multiple jurisdictions and tried to pick out what would work for us in Sri Lanka. And given that we don't, because this is a new law that requires a lot of change from businesses and enterprises and individuals, so to speak. Therefore, we've tried to avoid pitfalls that are experienced in other jurisdictions and try to cater to what is essentially required in the Sri Lankan context. And in relation to your second question about how to, whether this law accommodate situations like the pandemic, and like I said before, this is where that given that privacy and data protection is not an absolute right, there will always be competing interests. And if you look at I think the first schedule and the second schedule to the into the bill, there is provisions to process data in the interest of in the public interest or public health and safety. So it's I mean, the need of having a law like this is felt more than ever in a situation like this, because we see how sometimes the media tries to go after people who are found suspected of the virus, and then whether it's proportionate to that the end that is pursued by media is a question that is always asked in forums. So if we had a law like this, there's always provisions to cater for exceptions insofar as it's prescribed by law and it's proportionate and necessary to the end that is pursued.
Thank you, Sandhuni. I think Mr. Fernando wants to make one last comment on the data protection aspect.
Yeah, so Senura, the only thing I just want to add to what Sandhuni said in response to Chanakya's clarification vis-a-vis interoperability, with other norms and practices governing privacy data protection. Yes, in the process of drafting Chanakya, we had a frequent dialogue, not only with Europe, but even with US and APAC, ASEAN authorities on a kind of a compatibility that we would have when we formulated the data protection bill. And today perhaps is not the forum to discuss it. We will go into those details later. Subsequently, around December last year, we had a communication from the Directorate General of Consumer and Legal Affairs from the European Commission, basically commending our draft bill as being conforming to certain minimum standards. So what those are and how it works in practice is something we can discuss on a later date. Thank you.
I would like to take this opportunity to thank everyone who joined us and the panelists for an excellent discussion on the key points on data protection, cybersecurity, and the use of third-party intermediary platforms and the legal issues that comes out of. I know we are like nearly 15 minutes over time, and hence, without further ado, I would hand this back over to Pasindu to conclude the proceedings.
Yeah, thank you very much, Senura. That brings today's webinar to a conclusion. And I think all of us had a very informative, thought-provoking, and interesting session going into many aspects in this sphere. So once again, I would like to thank our eminent panelists as well as our moderator for sharing their knowledge and expertise with us. So please join us next week at the same time for another webinar hosted by the Bar Association of Sri Lanka on a very